quick announcement on the Wirewheel side. We're very excited to announce that we've just launched our new universal preference and consent platform. It's now generally available. And our new platform is really addressing those critical needs, specifically around some of the new laws in the United States and globally. And we're really, looking forward to working with companies, helping really solve for some of the new requirements around the country, especially around the Sephora enforcement decision in California.
We have a very important next session today. So we've had phenomenal entry sessions of, to the spokes winter 2022 already. We've covered the important topics of age-appropriate design and children's privacy. We've covered some of the key issues that have been coming up in enforcement, especially for digital marketing and ad tech under the California law. And in our next session, we're going to be covering the discussions around the new EU-U.S. data privacy framework. And we have two important speakers with us here today. I'd like to introduce Bruno Gencarelli from the European Commission and Alex Greenstein from the U.S. Department of Commerce. So Bruno and Alex, welcome today to our discussion around the new EU-U.S. data privacy framework, as it's called. Welcome to Spokes, Bruno and Alex, on behalf of our whole community. And thank you for joining us. Alex, I don't know if you were able to get your video and camera on, but welcome today. I'm going to jump right in. I'll give you a moment, if you don't mind, to just introduce yourselves and talk about the unit or the part of the government that you work with. And then we'll jump right in on the current status of the discussions around the new framework. So Bruno, do you mind jumping in first and just giving us a few moments on your role with the European Commission?
Sure, Justin, and thanks for having me today. And I'm also saying hi to Alex, who is very well known to me and to the team here. I work for the European Commission, which is the executive arm of the European Union in the department dealing with justice and consumers, and I'm deputy to the director for fundamental rights and the rule of law. And I'm heading a team. Also, I'm heading a team that is responsible for data flows and privacy. And in that context, indeed, I have been and I'm responsible for the new data privacy framework between the EU and the US.
Terrific. Well, I look forward to jumping in here, Bruno and Alex.
Great. Yeah, no, thanks for having me, Justin. I'm Alex Greenstein, director of the Privacy Shield framework at the U.S. Department of Commerce. And I run that program, but I've also been heavily engaged in sort of negotiating the data privacy framework with Bruno. And we'll sort of be overseeing sort of the transition to sort of the EU-U.S. data privacy framework here at the Commerce Department, which will probably entail changing my title, among other things. But certainly, yeah, but also we sort of work very closely with Bruno on sort of all aspects of transatlantic data flows and ensuring that they're appropriately protected.
Well, fantastic. Well, Alex, Bruno, thank you both for joining today. And obviously the privacy community and folks around the world have been tracking very closely, or as closely as we could, what's been happening in the discussions around the new framework. And just yesterday, we saw that there was a draft adequacy decision from the European Commission. We put it up for you, covering a draft finding on why the new framework is adequate. If I may, and I'll start, Bruno, with you. just for folks who are following it but may not be following all the technical ins and outs of an approval process or how the adequacy decisions come to be once you have, a general agreement on the framework, do you mind updating folks on what is this step in the process, and then how do we get to finalization of an adequacy decision?
Sure, and I realize that this is a slightly complex process. So we are not talking about an international agreement that has to be concluded and then ratified by the parties to that agreement, but we are talking about a decision that the European Commission can adopt to allow the free flow of data without the need for companies to put in place any additional safeguards or going through any authorization process. So to address the shortcomings of the previous framework, the Privacy Shield, as identified by our highest court, the Court of Justice of the European Union, we have indeed engaged in negotiations with the US, and we came to an agreement that was announced by President Biden and President von der Leyen in March of this year. And then that was further translated in US legal text, in particular the executive order adopted by the President on October the 7th. And it's on that basis, so those negotiations and the result of those negotiations are really the foundation of this draft decision that we have issued yesterday. What are the next steps? To be able to adopt this decision and therefore to have an adequacy decision on which companies can rely to transfer data, we have to go through a number of procedural steps that are part of our institution decision-making process, and that involves an opinion of the European Data Protection Board, which is the body that brings together our privacy regulators in Europe. Then we need to get a green light from the representative of the member countries, the 26 member countries of the European Union, that have to vote in favor of the decision we have tabled. And this whole process is also under scrutiny of the European Parliament, which is the parliament that is directly elected by European citizens, which can ask the Commission to either amend its draft decision or even withdraw it. And it's once we have completed that process that the European Commission can adopt the decision that then can enter into force and on which companies can rely. I guess, and I don't want to give you a too long answer, but I guess that your next question is how long this take and when this will happen. From the brief summary of this process, you will understand that it's difficult to foresee how long this will take, because not all of these steps are under our control. Each institutional actor can decide to take the time it wishes to scrutinize the decision before it expresses itself. But looking at recent precedents, this process takes around 6 months. So we are talking about, for final decision, we're talking about sometime in the spring of next year, before the summer, of course, if those different steps are positive. Sorry.
Perfect. That was covered fantastically well, and obviously there is a process to get from here to there. I'll just start with some questions that are probably on the minds of folks here today, Bruno and Alex. There are a lot of companies that had certified under Privacy Shield, are maintaining their obligations, they're doing what they said they would do, and they don't have the benefit of any sort of data transfer mechanism, notwithstanding that, because it's not been approved as an adequate means of transfer. So I'll just go through two things. I think I know the answers to this, but until this is finally adopted as an adequacy decision, can anybody rely on a Privacy Shield or, a pre-process of doing this to use this as a means of transfer? I suspect I know the answer to that. And then second, maybe, I'll throw the first question to you, Bruno, because it's more of a European side question. But obviously from your perspective too, Alex, you clearly must have a perspective on what folks can do if they're certifying under Privacy Shield. But a related question is just, a lot of companies are still doing transfer impact assessments for transfers to the United States because of the prior decision in Schrems, and there's no adequacy decision in place. How should companies, react until an adequacy decision has been finalized, if I may? Bruno, do you mind jumping in first, and then I'll.
Yeah. So, as a transfer mechanism, the Privacy Shield doesn't longer exist. The Privacy Shield is dead, and we are now seeing the development of a successor to the Privacy Shield. So, companies cannot rely on the Privacy Shield to import data from the EU. That's very, very clear. Then your second question, which is equally important, and which goes to a real benefit of this deal, is that we have negotiated those safeguards in the area of government access. So on these points that were criticized by the Court of Justice, so that they can benefit all transfers from the EU to the US, regardless of the mechanism, the tool you're using, model clauses, binding corporate rules, etc. And that's very important for those companies that, for a number of reasons, will not be able to be certified by the Commerce Department to rely on the adequacy decision. They will still be able, and that will significantly simplify the transfer impact assessment, to rely on those safeguards in terms of redress, in terms of necessity and proportionality. I'm using the future tense, will, because for that to happen, and Alex will probably say more on this, the US has to put in place those safeguards so that companies and individuals can effectively benefit or rely on them. What I'm talking about making sure, to what is called in the executive order designation process, that Europeans can lodge complaints with the new redress mechanism. The executive order also says that intelligence agencies have to review, update their internal rules, policies, processes to reflect the new requirements of the executive order, as the new requirements, again, around necessity and proportionality. And once this will happen, of course, those safeguards will be available, as I said, for any data transfer. You will also have seen, for those who in less than 24 hours had the time and the courage to go through our adequacy decision, that the adequacy decision, its entry into force, is conditional upon those safeguards being put in place on the US side.
That's perfect. Thank you, Bruno. Alex, do you mind if I pivot over to you? How does the Privacy Shield office think about these items right now?
Yeah, no, certainly. I mean, we've made clear sort of in the past that, I mean, Privacy Shield is no longer sort of a valid transfer mechanism following the Schrems 2 decision, but it still does sort of embody certain, best practices, and companies have continued to find that valuable and have stuck with the framework. We are committed to sort of helping companies transition their commitments under Privacy Shield, and there are a number of companies who have continued to do that, and they've continued to abide by their commitments to the new data privacy framework. And that's something that sort of we will provide guidance on in the near future. I mean, a lot of it will be sort of updates to their privacy policies, but that will not be sort of onerous. There will be a transitional period. And I think by and large, companies will not have to sort of substantially change their day-to-day operations. But there are sort of significant updates to the framework text that we have sort of made in the data privacy framework. As far as sort of transfer impact assessments, I mean, certainly companies have to follow whatever guidance they receive from their supervisory DPA on that. For the US standpoint, I mean, the executive order had the force of law when it was signed. And certainly there are sort of implementing measures that we have to take in order to sort of put it fully into force along with the commission. certainly, I mean, there is a time frame for intelligence community elements to adopt, I guess, sort of like specific sort of rules and like that reflect the executive order. I think they're given a year in the executive order to do so, but also that may happen quite much sooner. The Department of Justice is taking a lot of, is doing a lot of work right now in terms of standing up the Data Privacy Review Court. Actually, someone forwarded me just the other day, it was actually a job notice for the at the Department of Justice for someone to work and support the court, which is sort of indicative of sort of the concrete things that they're doing right now. And then also, of course, the United States does have to, I guess the Attorney General has to designate the European Union as a qualifying state for the redress mechanism to be available. But those are all sort of implementation issues that we are, discussing and working on in parallel with our colleagues at the Commission.
So the work doesn't stop, Alex. You have a lot
We
going
don't
on.
get to sort of like, say it's all done and over, but it's moved to a next phase, and it definitely has shown significant progress. And we're really happy to, been able to see the Commission release their draft adequacy decision.
So one thing to consider, I was kind of curious, is this is a minor issue, but you may not be able to comment on it as usual. The whole naming thing, it's just kind of like, the whole purpose of these frameworks is it's not a treaty. It's supposed to be a flexible framework. Bruno and Alex, there's an annual review. You're going to do tweaks to these kinds of frameworks on a regular basis. That's kind of the purpose and a benefit flexibly of these kinds of things. And yet we've renamed it. We've renamed the data transfer mechanism now twice, Safe Harbor to Privacy Shield to the EU-U.S. data privacy framework. Do you have a view as to what will cause a renaming? Is it going to be a major revision, a minor revision? And is there a reason behind it that you see to rename it each time?
I think what is important is that we get the right content. The name is a secondary issue. I think there is indeed a new name, which is a EU-U.S. data privacy framework, that is there to signal that this is not just an evolution of what there was before. And if you want, we can get into that. It's a significant improvement, a major change. And I think that when you change something and you significantly change it, it's also, you expect that you will call it in a different way. But I wouldn't give too much importance about this name things.
Yeah, I mean, the other aspect of it is that, I mean, what was agreed to by the presidents back in March is quite significant. And we wanted to sort of really make clear that sort of this is sort of like, tied up in that. And that sort of this is sort of these national security commitments are sort of a part and parcel of the transfer mechanism. And so by sort of bringing those together under sort of the name of the EU-U.S. data privacy framework, it makes clear that as well as being a transfer mechanism, it also has these national security commitments that enable transfers under all mechanisms, including the standard contractual clauses, binding corporate rules, and other mechanisms.
That's really helpful. So it's being sort of indicated as a major revision and a major new set of commitments is what folks can take from this in part. You probably have seen the same things we have seen just in the community, which is, there may be challenges to the next version of it. And I'm sure this comes up when both of you are speaking about it. You can never prevent somebody from challenging something that's actually out of the control of the folks negotiating. It's out of the control of the country. Folks will challenge it. But when you're trying to talk to the community about why we feel like this, has met the requirements, do you all mind covering that for the community? Why should they sort of think about this as a means of transfer they should get behind, perhaps, if I may?
Should I
Do you
start?
want to go or shall I?
Yeah, since those are the requirements we have to meet, so maybe I should start. That goes back to what I was saying before. Why this is not just an evolution, but is a significant improvement of the situation. And let me maybe also step back. When we developed the Privacy Shield, we had as the basis the Schrems I judgment. The Schrems I judgment didn't say much. It said that the safe harbor had been annulled because we simply didn't know we had to consider government access to data, to follow the data through its lifetime. Schrems II said much more about what we had to do in terms of meeting the various requirements on necessity, proportionality, and redress. Schrems II actually gave us, as negotiator, a quite detailed mandate. So we knew much better what we were looking for. So, and clearly this guided the negotiations. Probably my US counterparts were tired of listening to me referring, and I hope not too much, but lecturing about the Schrems II judgment. And on all those these aspects that were at the core of the Schrems II judgment, you can see the significant improvement I was mentioning. The Privacy Shield was based on just, and I'm putting, of course, that between inverted comma, a description of existing US rules. The data privacy framework is based on a new piece of US law to an executive order that introduced new safeguards as regards necessity and proportionality, basically when and to what extent intelligence agency can collect data. The Privacy Shield was redress part was essentially based on an ombudsperson, a person with all due respect for the different person who filled that job and for the Department of State, but the person who was part of the Department of State and who had no specific and certainly not any binding investigatory, adjudicatory, or investigatory or remedying power. The redress body we have now is a tribunal with a number of independence, safeguards, removal protection, etc., and very important, and very importantly, binding powers in terms of handling, resolving a complaint and remedying a violation if a violation of the law is found. And there are other aspects of that that really enhance and make this an independent tribunal. So those are very big changes, which we believe, on the basis of which we believe we can credibly defend the deal.
Well, and it's important the point you made at the beginning, Bruno, and Alex, please jump in.
Sure.
You know, these means of redress apply to all of the means of transfer that apply between Europe and the United States. And so they do assist if you have binding corporate rules, standard contractual clauses, or you're certifying or self-certifying under the EU-U.S. data privacy framework. That's part of the reason this is so critical, because the redress mechanisms cover all of them. The reason I'm framing it this way is on the private sector side, a fair amount of questions come up of why, if we went through the effort of putting together standard contractual clauses or a binding corporate rule in the absence of Privacy Shield during this window, why and how should we certify under the new framework? And maybe, I don't know, Alex and Bruno, if you all have a way to think about this, but for the community, when should they think about which version to adopt? In other words, when should they think about, again, this may be an area you cannot cover, but when should they think about a binding corporate rule? When should they think about standard contractual clauses? And when should they think about trying to certify under the EU-U.S. data privacy framework?
I mean, I guess I would say that that's sort of very particular to sort of like the company's situation, and sort of, I mean, it's a very like choice for them about sort of what their data transfer situation is like, what their business model is. I mean, BCRs can take a while, but if they already have it established, that's good. I mean, the differences there I'd see are like also that privacy, or the Privacy Shield in the past has traditionally been very popular among small and medium enterprises because it is definitely a much more accessible and affordable means to comply with GDPR transfer limitations. And so certainly I think that would apply as well to the data privacy framework. But also I think in the past we've had some companies who have used SCCs, but they've also used Privacy Shield and view it as something of a gap filler for other transfer situations that aren't well covered. So I think there's room and utility for sort of all these transfer mechanisms. But the important part here is that we really did sort of listen to the European Court of Justice in Schrems 2, and we wrote these national security commitments in order to like meet those conditions. And that's why we think this will be a durable mechanism.
Bruno, do you have any perspective on it? What if a company put in place SCCs, should they try to go and also do a certification, or is there any benefit that overlaps, or as long as you have one, because the redress mechanisms cover all, you may not need to do more than one? Is there a way to think about that from the commercial side?
Well, first, I just want to echo what Alex just said. I mean, there's a certain flexibility, and we want to keep that flexibility in terms of transfer mechanism and that sort of broader toolbox. And the choice might depend on many factors, such indeed the size of the company, the business model, the type of transfers also. If you're transferring within a corporate structure, one corporate structure, of course, BCRs are available. They are not available in other situations. But I'm thinking also of those companies that cannot certify under the future data privacy framework because they are not under the jurisdiction of the FTC or the Department of Transportation. Thinking, for instance, of many companies in the financial sector, they will not be able to benefit from the certification for question, which is a question which depends purely of US law and of how the jurisdiction of the FTC in particular is constructed. So that's why it's not only about the review, the redress mechanism, but also the safeguards in the area of necessity and proportionality. That's why it is important to have those safeguards applying and those redress mechanism applying across the board, so that companies can, in a certain sense, freely choose the transfer mechanism, which is adapted to their needs, while benefiting from those safeguards, and therefore not having to carry out a very complex part of the transfer impact assessment.
Yeah. Well, again, so this is a perfect bridge to another question we've received already. By the way, we have a fair number of questions being posted, and we're going to come to these now momentarily. And for folks joining today, if you do have questions, please post them to the Q&A, and we'll make sure Bruno and Alex get a chance to answer them. One item that comes up a fair amount on the US side, Bruno and Alex, is you have one of the first major comprehensive privacy laws coming into effect here in January with California's CPRA. The CCPA was a somewhat more limited set of coverage, Bruno and Alex, as you both know. And many consumer brands in the US are now preparing to comply with CPRA, which has a lot of parallels, Bruno. I won't call it overlapping, but parallels with the principles covered in GDPR, for example. One could call it, at least it's something that might be amenable to an essential equivalence, type analysis. Obviously, with adequacy coming into effect, once the adequacy decision for the new framework is into effect, those redress mechanisms are available for all purposes. And that means that a part of the United States, like California, could get the benefit of an adequacy decision for something like CPRA, Bruno, as I understand it. Have you all mapped, for example, at the Commerce Department or looked at CPRA and seen how it might overlap? I realize it's a state law, by the way, Alex. It's not really a federal law issue. But have either of you looked at this as a possibility in terms of a company complying with California law and then getting the benefit of essential equivalence or adequacy, Bruno or Alex?
While Alex is mapping Californian law, maybe there's one, because I understand that there might be some confusion between these different pieces. The arrangement we concluded is addressing not only, but mainly an issue which is exclusively a federal issue, which is about the rules that apply to access to data by intelligence agencies. I'm not an expert of U.S. law. I'm not an expert of U.S. constitutional law. I'm not an expert of Californian law, but something I can imagine, and I think I know, is that the rules on surveillance, especially on foreign intelligence, are a federal competence. So we, by addressing those safeguards and by adding safeguards, including in the area of redress, we are facilitating transfer to any part of the US, including California. Then when data is transferred to the US, and in this case to California, once the data has landed, if I may say so, in California, that data benefits from a higher, better, I leave that to observers and commentators, a level of protection when it comes to handling by commercial operators. That's, of course, something we welcome, and that can certainly strengthen the overall situation in terms of protection.
So in other words, if California came and they sought an adequacy ruling, it would at least be possible. It would be the kind of thing that it would be the kind of thing that the European Commission could consider. It would be much harder, perhaps, for that consideration to take place if you didn't have the new EU-U.S. data privacy framework that had been approved for an adequacy finding. But once it has been approved for an adequacy finding, it sets the legal basis, perhaps, Bruno, for California seeking adequacy for the CPRA. Is that
that's absolutely true, and it's true for California as for any other state which would have an interest in this area. Meaning our powers in the area of adequacy provide for the possibility to adopt adequacy that are limited to a certain region, area, industry, because we know that around the world there are federal states, and in a federal state, a sub-federal entity might be able to adopt privacy rules, which is the case in the US. Therefore, in a certain sense, we have solved the issue that no state could solve, because we're talking about something which concerns federal rules. Once that is done, if California, and I know that some in California have expressed an interest for that, and we welcome that interest, if California or any other US state that has privacy legislation would be interested in exploring that possibility, we would certainly explore that possibility with them, yes.
The way I like to think about it is that sort of the national security commitments that we made in the executive order, those sort of like, float over top of all the other sort of transfer elements. And so once that national security issue has been resolved and the protections are deemed adequate, then in order to fulfill sort of the commercial requirements for transfer, you can choose whatever sort of mechanism you want, be that sort of like, the data privacy framework, standard contractual clauses, or sort of, compliance with state laws.
That's that perfect summary. And obviously there's a lot of hope that once the adequacy decision comes, Bruno and Alex, that, obviously you want to simplify it for companies. So if they are complying with California, or they are complying with Privacy Shield and now want to comply with the new framework, any guidance you can give about ways companies can do the right thing and then benefit from it in multiple ways is obviously tremendously helpful. Alex, maybe I'll ask some kind of technical questions here. If a company's certifying under Privacy Shield, once the new adequacy decision comes up, is there a plan of migration, or is there a plan of recertification, or what do you expect companies will be asked to do, if you have a perspective on that yet?
We're going to be providing guidance to companies on sort of what that transition will look like. But certainly, I think that, I mean, there will be a transitional period where companies will have to change their privacy policies and in order to reflect sort of the new framework. And that is sort of how we're looking at sort of like transitioning them over. I mean, sort of many companies, we will be able to catch them in their annual recertification process. But like, you know, some companies, yeah, may have to change it sort of outside of like that normal process, and we'll work with them on that.
Well, is there any guidance that you can point to, or Alex, or you could summarize for companies in this regard? And the reason I ask this is most of the things that are talked about publicly on the new framework focus on the executive order, and there's less emphasis on the changes that are being made from a commercial. I don't know if you even call them changes, but updates, clarifications, whatever the right terminology may be. So for folks who are thinking about that, on the commercial side, how should they think about what they need to do differently, if I may?
I mean, I think that, like, I know a lot of, I think in terms of like, you know, companies shouldn't be changing their privacy policies right now if they're in Privacy Shield. We'll be providing them guidance about sort of how to transition their commitments over to the data privacy framework. I think by and large, like, you know, that will not be sort of too onerous. I mean, largely it's sort of changing references to sort of like, you know, the prior framework. Also, I mean, the Privacy Shield was done in light of the 95 directive. And so there are some instances where we've changed references to the GDPR. If companies are, for instance, quoting directly from sort of the Privacy Shield framework where it refers to the GDPR, then that would naturally need to be changed as well. But these are all sort of details that we are prepared to work with companies through in order to sort of make sure that there isn't a gap in their obligations. Because, I mean, that is the other aspect of this, that Privacy Shield has remained enforceable by the Federal Trade Commission, and if companies, and they've enforced that. And so we want to ensure that there isn't sort of an enforcement gap there, and that sort of companies can be smoothly transitioned into the new framework and the commitments they're under.
Yeah, so I mean, again, I know folks can read the draft. I'm certainly not asking for a legal opinion, but on a quick read, it didn't look like a huge change. I know it's hard to characterize in terms of the commercial obligations. So maybe it's some language updates and some technical changes, but big picture, should companies think about themselves having to do a ton of new things under the new framework if they were keeping up to speed on Privacy Shield? Is it commercially? It didn't look huge from what I saw. It looked largely focused on the executive order side. Is that fair?
Yeah, I mean, I think it's fair to say that sort of like, you know, companies will not have to sort of like, you know, significantly change sort of like what they're doing commercially. And there will be sort of continuity there. I think there are significant updates that also reflect what we did during the annual reviews of Privacy Shield. And it certainly does sort of update it to reflect sort of the general data protection regulation. But I would say that sort of like, you know, companies' commitments will not significantly change, because there wasn't sort of that wasn't an issue in the Schrems 2 judgment. There haven't been sort of significant concerns raised over the commercial aspects of the framework.
Let me maybe add on this. Indeed, there maybe no significant changes, but a number of improvements and clarification, including building on the annual reviews. I perfectly agree with Alex, and that shows that this is, you know, we are not talking about a static instrument.
Yeah.
The annual reviews are not just there, you know, or the periodic reviews are not there just for the sake of meeting in Brussels or in Washington. They are really there to identify questions and resolve them and improve the functioning of the system. So some clarification, for instance, in the area of research, health data, around key coded data and the fact that key coded data the transfer of key coded data can now will be now covered by the new adequacy decision and the new mechanism that might be important for some companies, and many improvements, I would say, around supervision by the DOC, by Commerce, and enforcement by the FTC. As you know, the safe harbor, to a certain extent, the shield was often criticized because supervision and enforcement was seen as perceived as too reactive. So through the annual reviews and building on what we had discussed in the annual reviews, we have now made sure that there will be more proactive enforcement, proactive supervision, proactive enforcement by the FTC, proactive oversight by Commerce, that will not only look at formal and certain observers would say formalistic issues in terms of compliance, but also more at compliance with the substantive requirements. I think that's, in terms of sustainability of the deal, is a very important improvement.
That's very helpful, Bruno and Alex. And I know we're asking you about things that are company side, and you can't really opine on a company set of views. So it was more just if there were simple ways that companies could understand how their obligations are changing, or if you have any sort of guidance that is a summary of that. But it sounds like, Alex, what you're saying is that's coming, and that companies will be able to prepare ahead of time.
Yeah. The one thing I'd say is that sort of like, in terms of sort of who can use sort of the data privacy framework, I mean, we were very intentional in terms of there should not be any sort of situations where you were able to previously transfer data with Privacy Shield that you would not be able to use the data privacy framework for that. But in some situations, such as with key coded data, now the DPF will actually cover things more broadly and actually expands what types of data can be transferred under the mechanism. And the key coded data is quite significant for companies in sort of like the life sciences field, and that's definitely responds to sort of something we had gotten a lot of interest in from industry, and we were really happy that we were able to work with the commission to make that happen, particularly in light of I mean, all the work that's gone into vaccines and whatnot in the past couple of years.
Well, there's a lot of questions, but I'm going to put them into buckets because we only have a few minutes left, if you all wouldn't mind. These are my characterizations of a whole group of questions. So again, feel free to answer what you can, and Alex and Bruno, what you can't, don't worry about it. One is, and this is an interesting one, how can the safeguards of the executive order, the way the question's phrased, overrule the Cloud Act and Section 702 of the FISA amendments of 2008? Now, I know just technically speaking, you can't overrule a statute by an executive order. So I suspect that the questioner's getting to some tensions between the two. And to be honest on this one, I don't fully know the tension. So I'll leave that as one potential question. Alex and Bruno, another one that I'd say is captured by a number of different questions is just, do we really believe that these amendments, especially in the executive order, address the concerns raised by the court in Schrems? I'd say that's a collection of questions. And why do we feel that way? Maybe is a way I would summarize it. And then a third group of them, which I think have already been answered, come down to the basic point that I think both you, Alex, and Bruno covered. And I'll summarize it this way, and we'll maybe put those questions aside. Right now, Privacy Shield is not a means of transfer. It is still being enforced by the FTC if you certified. Mm-hmm. And the hope is that if you're subject to something because there's an issue with the FTC, you're still going to have to deal with the FTC on those kinds of issues. That, if I'm understanding it properly, notwithstanding that it's not a means of transfer, Alex.
Yeah.
So did I get those 3 points basically right? That in terms of the current status of Privacy Shield and enforcement actions?
Yeah, no, the Privacy Shield, I mean, the public commitments that companies have made there are still enforceable. And so if companies said they will do certain things, FTC is still prepared to sort of enforce on that.
Perfect. Okay, so I covered those three. then if I may, on the the two major subjects are really covering the same thing. One is, why do we really believe this will meet trends? And if you don't mind giving your perspectives on this. And two, is there some tension between some statutes like the Cloud Act or Section 702? If you feel comfortable answering those two.
Okay. I'll give a try, and then Alex probably will complement and add his own perspective on this. So indeed, let's make a step back. Why was the privacy shield crushed by the Court of Justice in the Schrems II judgment? Essentially for two reasons. First reasons, absence of binding and enforceable safeguards reflecting the principle of necessity and proportionality. So what is necessity and proportionality? Safeguards, therefore, that since we're talking about data imported from abroad that also apply to non-Americans, safeguards that ensure that when, for very legitimate reasons, intelligence agency want to collect data, to access data, there are rules in place to circumscribe, define when they can collect that data. That's the necessity, if you want, and to what extent they can collect that data. That's the proportionality part of it. No rule, no enforceable binding rules in that area, or insufficient rules in that area, I should say, because there were rules, but they were considered insufficient. And then one problem with PPD 28 is that PPD 28 was not really enforceable, didn't create enforceable rights. Second problem, no sufficient redress and sufficiently independent redress mechanism before which you could invoke those safeguards. On these two aspects, the New Deal provides for solutions that are, as I said, not only an evolution of the privacy shield, but a significant improvement. We have already discussed this, but on the first point, while again the privacy shield was based on a description of existing rules, including the one of Presidential Directive 28, which were certainly interesting because they apply across the board, including to non-Americans. Unfortunately, they were not considered sufficient, and they were not considered as being the basis for enforceable rights. The executive order provides for those safeguards, and contrary to what I often hear, the executive order doesn't only pay a lip service to necessity and proportionality, but spells out what necessity and proportionality means throughout the life cycle of the data. Which objectives are legitimate objectives for national security collection, for signal intelligence collection? This is defined both in positive terms and in negative terms. They are objectives that can never justify such collection. Then, when collection is necessary to advance a legitimate national security goal, that's also spelled out. And then when we come to the proportionality part, which are the factors that intelligence agency should take into consideration, should balance when considering collection, method of collection, technique, etc., amount of data collected. And there you find the typical factors: seriousness of the threat, likely impact on individuals, duration of the collection, nature of the data, whether sensitive data or not. You take any judgment of the European Court of Justice, of the European Court of Human Rights on proportionality in a similar situation of balancing privacy rights and national security needs, you find exactly the same list of factors. So that should provide confidence not only to your audience, but to those looking at this deal, and certainly make us think we can defend credibly that part of the deal. And the second part is, of course, the redress one, where, again, we believe, a redress body that has all the characteristics in terms of independence and power I have mentioned. There are also other aspects that are interesting. For instance, the role of the special advocate. That's important in terms of due process or adversarial process. We make sure that this will not only be a conversation happening behind the door between the court the data privacy or protection review court and the government, but there will be somebody whose mission will be exclusively to represent the interest of the complainant. That's, I think, an addition. And there will be also a further guarantee in terms of independence, which is the role of the P Club, the Privacy and Civil Liberties Oversight Board, which will have to certify every year that the redress mechanism works as intended, and that any decision of the court, the new court, is fully implemented by the intelligence agency. That's a further important guarantee in terms of not only functioning, but independence of the system. I could go on for hours, but I will stop here.
Well,
But I think that by
Bruno,
mentioning those elements, I think everybody realized how different this is from what there was before. And then on the second question, which is what is the relationship between this and existing statute? Well, if we take section 702, section 702 has a number of protections that apply essentially, that are relevant essentially, but not only to Americans, because it's about making sure minimizing collection of data of American citizens and or permanent residents. There are also protections that directly or indirectly benefit everybody, but the protection of the executive order come on top of those protections. There are no contradictions, so they can very well complement the safeguards that exist in legislation. And we had a discussion, we discussed this at length. And there's even a clause in the executive order that says that the most privacy protective rule will apply, which is also important in an area of law where there might be part of the rules that are not easily accessible. Let's put it like this. So we don't see any contradiction between existing statutes, existing statutory law, and the executive order, but we believe that the safeguards of the executive order will complement those that already exist in US law. And that's, of course, very important, knowing that those safeguards of the executive order create a legal entitlement for, in this case, Europeans, who will be able to invoke or allege their violation before the redress body. Again, a very big difference compared to PPD 28, which said that that the protection of PPD 28 were not enforceable.
That was fantastic summary, Bruno. I assume, Alex, you would say ditto, or
yes.
like right
What he
there.
said.
Right, yeah, exactly. And Bruno, that's what we call in our side of a softball. That's because, I mean, obviously you've been out there preparing an important adequacy decision, draft. And I mean, let me just say on behalf of the whole community, I know both of you and your teams and a very broad group of team members across the United States government and the European Commission have been working on this diligently. And I know how much goes into solving some very, very difficult issues. They're tricky because you're balancing different legal regimes. All of us are very grateful for all the work you've been doing. And these are always, I mean, no matter what you do, you've done an incredible job of trying to bridge. You can't stop a challenge that's not within your power. And Bruno, you did a terrific job of summarizing just how significant both sides have made efforts to bridge across these issues. Getting to a draft adequacy decision and starting the process of finalizing is a huge step in the process. I want to congratulate you both on getting to this step, and we're all rooting for you, and getting it across the line because of the effect it has on so many businesses and people. I mean, fundamentally, this enables data subjects in the U.S., human beings or consumers, as we call them in the United States, Bruno. It's meant to protect privacy, and I think it's an important step, and we're really excited to see where it goes. And in the coming, you'll see, in additional panels, we have a very important panel. Cam Carey will be covering tomorrow on perhaps federal legislation and where it comes. And Cam's been doing some really important work at Brookings on driving that forward. And the state laws here in the United States are making very big movements forward as well in terms of comprehensive coverage. So I think this is a big part of the movement, but there's a lot of things going on in parallel. And I want to thank you both for all you've done, to advance this. One more time, thank you for coming to Spokes, Bruno and Alex. Is there any closing remarks or anything before we invite you back for next time?
No, just thanks for having us, and we're glad to sort of, be able to sort of move forward with this to, enable sort of those data transfers that help sort of companies and individuals in Europe and the United States.
Bruno, you get the closing word. You're the star of the show as always.
No, well, no. This is teamwork and transatlantic teamwork. So thanks for having us indeed, and see you next time. And this is important indeed for the whole community, and we're of course available to answer any question.
Terrific. Thank you both. And our next panel is actually, as I mentioned, an all-star panel that's going to be doing post-game analysis on the discussion we just had with Alex Joel and Shannon Yavorsky and Travis LeBlanc, together with Peter Swire, folks that you all know well. I'm going to hand it over to Chris to close the session, and Bruno and Alex, we'll see you soon.